And another great reason not to have my case meetings on the public visitation box is my personal, confidential inmate information, such as my visitation lists, 2020 through 2023, with names, etc., my interactions with inmates and officers, what I eat, when, and my personal jail calls also being thrown online. For what? To hate me more or try to get others to because I don't eat breakfast or because I know some Latin, have short hair, my penmanship is nice, or because I'm not getting fat and sleeping all day, but rather fully applying myself, fighting, still, making everyone upset for not having to fabricate, mutate, splice, edit. The world apparently knows all. What's next? How many times I go to the bathroom and what function I perform? Hello, and welcome back to WordWise. I'm your host, Kit, and today we'll be discussing Sarah Boone's 12th through 18th letters. I'm recording this on Sunday, October 20th, so we've only had one partial day of trial, and so far, I'm a little concerned. The prosecution is still finding their footing, I hope. Meanwhile, let's jump right in. The first letter we're going to discuss isn't related to Sarah's crimes against George Torres. Before her arrest, Sarah was living off the alimony that her ex-husband Brian Boone was paying her, which I've heard was about $1,000 a month. And several years after she was arrested, Brian petitioned the court to have the alimony reduced or eliminated. Sarah was not happy, and she wrote this letter to the judge in her family court case. Normally, family court cases are sealed, but somehow this letter has been made public, so let's take a look at it. I want to mention that because this letter isn't available on the county clerk's website, I had to transcribe it from a Lawyer You Know video. Thank you, Peter. So the visual excerpts won't be in Sarah's handwriting. I'm sure you're devastated. Anyway, any inaccuracies are mine. Motion to read letter from respondent and schedule case management hearing. Judge Michael Dean. In all my attempts, 16 plus, to protect myself and help from the still ongoing hate, lies, slander, degradation, cruelty, and active mistreatment from former husband Brian C. Boone, nothing has been improved, made better, corrected, relieved in any way for myself, the respondent, from former husband, the court, or judge. I have tried everything. I have made innumerable requests and sent many letters asking for aid from all with no success or assistance, listening or care by anyone other than myself, trying to relieve or altogether stop his inappropriateness, bitterness, anger, and wrongdoing. You know who sounds bitter? In all seriousness, I don't want you to believe anything Sarah says here about Brian, and she's going to talk a giant floating garbage patch of trash about him. As a lot of people in the true crime community have pointed out, Brian is a victim of Sarah's too. George wasn't the only person she laid hands on. Besides which, Sarah's just a huge liar, and she's going to put the word husband in scare quotes over and over. It kind of blows my mind how committed she is to diminishing Brian's position in her life. But she does love societal roles, and I think that to her, husband in quotation marks is a real insult. Please see list below of my letter sent to you in the court, per the Records Management Division of the Clerk of Courts when for the third time tried getting a copy of my active dissolution of marriage agreement. I cannot because they are wanting payment in order to receive and I am in jail. I also have no bank account after the one I had was closed after having for 30 years due to non-payment of alimony from former husband and stated in prior letters. I love how she talks about this bank account like it's something to be proud of, like it's an accomplishment. I had the same bank account for 30 years. Okay, it's just the most bizarre flex. Have you ever had your local branch send you a Christmas card and it's signed, "From your Fifth Third Bank family," and you want to puke? Apparently Sarah believed in the sentiment of that card. Then she lists the date of every letter she's ever sent to this judge, organized chronologically into columns by year. This seems to be part of her argument that the judge isn't paying attention to her. She gets very triggered when she feels she isn't being heard. And everyone likes to feel heard, that's relatable. But the way she flips out when she thinks someone is ignoring her is intense. It is appalling how uninterested, uncaring, and nonchalant you and the justice system are about my side in any of this, and will not listen without the right paperwork and attorney, knowing I am actively being taken advantage of and wrongfully mistreated by former husband, Brian C. Boone. I don't know what she's talking about with the paperwork, but let's look at her characterization of Judge Dean and the justice system itself. She describes them as uninterested, uncaring, and nonchalant, which is one of her favorite words. So what she wants is for the judge to be interested, fair enough, caring, not really his job, and then basically interested again. That's the opposite of nonchalant. I think what she really wants is for the judge to understand her point of view completely. I think the fact that she writes "my side" in all caps means she really wants us to see it as important. And did anyone else find it strange that her lawyer Owens used that phrase in his opening statement? He specifically said that she had a side too. And it made me wonder if Sarah had a hand in writing that statement. Obviously, she didn't write the whole thing because it would read like this letter, but I think there's a very strong chance that she contributed ideas, points, and even phrases like "my side" to Owen's statement. If you watch her in court, she's obviously enjoying cosplaying being an attorney. It's bizarre. You have continuously enabled him and given him a self-appointed right and understanding to keep doing, saying, and taking everything wrongfully and illegally from me, including and especially the love and respect from my son. It is not okay. So she feels that Brian is taking everything from her, including the love and respect of her son. I believe her son would have been about 12 at the time she wrote this. He was 9 when she was arrested. I haven't confirmed this, but someone mentioned that Tanika from Tanika's 2 Cents looked at Sarah's phone records in jail and determined that she spends about 2.5 hours a year on the phone with her son. If that's accurate, I probably spend that much time on the phone with my mom every month, and she lives next door. Before I read this next section, I just want to point out how hard this must be for Sarah's son. He's almost 14 now. It's a fraught age for mothers and sons anyway, but I'm sure he's getting teased like crazy, maybe even bullied because of what she's done. She doesn't appear to have been a stable presence in his life before she went to jail, and now she's barely in contact. Although I suspect he has a pile of letters of his own. And people can say he's better off with her in jail. I don't know if that's true. I'm not a child psychologist. But every kid wants a good relationship with their parents. It's the parents who screw things up. I do think Sarah's son is completely justified in being angry at her. And I want to point that out before we read these quotes from her son and from Brian. As I said before, I don't know if these are real. I'd put it at about 50-50. I'm just offering them as evidence of how Sarah sees Brian and their son. "You're a killer. That's why I'm not doing anything," former husband said in front of son on phone. "You are not important to anyone," former husband, numerous dates. "You are not priority," former husband, numerous dates. "Dad says you're annoying and beg all the time." Son, told me after asking him to ask former husband if he finally ordered a book and hot meal after being made to call daily to check for 13 weeks. "I lie to you because I can. Dad does all the time." Son, "You make no difference in our lives." Former husband, numerous dates, September 4th, 2023, recent. Now, if Brian has been saying these things to their son, that's not ideal. Part of why I decided not to have kids is that I know parents have to suck up their feelings all the time, and I'm not very good at that. But if Brian did say these things, I can see why. Sarah called him every day after they were divorced. When she found George in the suitcase, she didn't call 911. She called Brian. She kept him emotionally involved long after their relationship ended, and I wouldn't be at all shocked to learn that she manipulated him using their son. He told the police he didn't even feel like they had shared custody, because even when their son was with Sarah, he had to be on call because he never knew when she might demand that he come pick the kid up. What he says here is, you aren't important or a priority, you're annoying, and you make no difference in our lives. I bet after being codependent with her for so many years that he feels really free. And maybe that feeling of freedom enabled him to say, no, I'm not putting you first anymore. I bet it's really nice not to feel powerless anymore. That said, if this is accurate, Brian probably shouldn't be complaining about Sarah to their son, and neither the son nor Brian should be lying just because they can, but I definitely don't believe that one. But let's assume, for a moment, that Brian's never said any of this. The son either. Let's assume that whatever they have said, this is how Sarah interpreted it. This is what she heard. She's afraid that no one will do anything for her, that she's not important, not a priority, makes no difference to people, that she's annoying people with her begging, and that they're lying to her. And isn't it fascinating how closely those interpretations line up with all her complaints about her lawyers and Judge Wooten? She claims that both Brian and Judge Wooten told her she wasn't a priority. And that makes me wonder if either of them really said that, or if that's just what she heard. Because I rarely hear people discuss whether or not someone is a priority to them. I'm not saying it couldn't have happened. I'm just saying I find it a little suspicious. Sarah is terrified that she doesn't matter, and she's projecting that fear onto everyone around her, or even people who've gotten away from her. Sarah demands to know why Judge Dean allows Brian to treat her this way. I have no experience with these types of cases, but Peter, the lawyer you know, says that these aren't the sorts of issues judges usually get involved with. They might instruct people not to speak poorly of the other parent or give a little lecture about how this can negatively affect children, but it's not like they're going to bug people's houses and monitor the way they speak to their kids. The judge can't order Brian to make Sarah a priority in his life. She explains how Brian justifies Judge Dean's inaction. This is apparently a quote from Brian. The judge doesn't care what you write. My son now says the same when I correct him on how he is being mean and rude to me. He's never going to do anything for you until your trial is over, and even then it will still all be in my favor. My other document is ready to go so I can take the rest. I have an attorney. You deserve nothing. You mean nothing. The thing about this is, Brian's right. Judge Dean is going to respond to this letter by saying that the family court case is on hold until after Sarah's criminal trial, and he's not budging on that. I suspect he had already informed Sarah of that on numerous occasions. And even if Sarah is miraculously acquitted, Judge Dean is still going to take Sarah's involvement in George's death into consideration when deciding custody. As for you deserve nothing, you mean nothing, I feel like that's probably more of Sarah's interpretation. I am curious what it means that she thinks Brian wants to take the rest. What does she have left? Then former husband gets his precious attorney to file another answer denying allegations because I'm telling the truth all the time about his awful lies, and I am right. I feel like we should start a list of red flags to look out for in people, and the use of scare quotes and an obsession with being right should go at the top. Judge Dean, so I have to continue taking former husband's abuse, neglect, unlawful actions, cruel comments, and hate until my trial, when it happens? If or when? What does she mean, if? If she's thinking there's a chance the judge will eventually get fed up with her delays and dismiss the charges, I think she's sadly mistaken. I don't generally subscribe to the theory that Sarah's behavior has been a delay tactic, especially because it sounds like she can't wait to attend her lustrous trial and tell her story to the world. Maybe Sarah just thought if when sounded smart and didn't think about what it actually meant here. She wants a case management hearing. That is her current goal. I am requesting again, please, to schedule. It is fair, and there are too many topics to be discussed, including my attorney, to write, and I only have one pen. Necessary, lawful, active, important topics. I think she keeps using the word active because it has some legal importance to her, because she refers to her divorce case as still being active. But I don't know why she would say that the things she wants to discuss are lawful, unless she's been told previously that bringing them up is unlawful. Is that possible? I don't know. This is not my area of expertise. Please grant my motions and schedule my imperative, overdue, owed meeting. Everyone needs and must have the same understanding now and future. It is fair. I feel like she's falling apart mentally and emotionally here. This is borderline gibberish. She's really not expressing herself the way she usually can. And I'm astonished by how entitled she sounds when she says that the judge owes her a meeting. What else can I do? What's left except for begging, which former husband says I do all the time? What am I doing wrong in order to be treated rightfully, properly, ethically correct in order to finally receive your judicial assistance? How I am and have been and will be treated by former husband, Brian C. Boone, is unfair, malicious, and wrong, and should not be in any way allowed to continue. Stop. Please see. Please listen. Please help. She's so upset that she accidentally asks for the exact opposite of what she wants. She ought to be asking what she's doing that's preventing her from being treated rightfully, properly, etc. Interesting that she instructs the judge to stop when it's really Brian she wants to stop. She seems to conflate them for a moment. Then this series of orders, please see, please listen, please help. I almost feel like she's reverted to being a little child. She does a fake baby voice at times. I'm sure we'll hear it in court. She closes the letter, then writes at the bottom, please send a copy of this letter so I know it was received and will serve as my receipt. Thus ends Sarah Boone's 12th letter. 3 days later, Sarah attended a hearing on her lawyer, Bankowitz's motion to withdraw. Judge Kranick's history of the case says, Bankowitz addressed defendants' derogatory statements, i.e. dud, buffoon, and berating behavior. Judge Wooten agreed that Bankowitz should be allowed to withdraw. He assigned Sarah a new attorney, and they set a new trial date. Here's another quote from Judge Kranick's order. After setting these dates, the court pointed out the deterioration of the working relationship between defendant and Bankowitz. The court further cautioned that if this becomes a problem on another court-appointed attorney, I'm going to look more closely at what the alleged disputes are. The court further advised that there are certain decisions the attorney gets to make and certain decisions a defendant gets to make, i.e. go to trial and/or testify. The court cautioned as to defendants' unrealistic expectations regarding court-appointed counsel and reminded defendant of her right to retain private counsel. During a hearing in this case last week, the defense tried to enter hundreds of pages of Sarah's medical records from her time in jail into evidence. The prosecutor read a bit from her jail intake evaluation, during which she was observed to lack insight and have unrealistic expectations. That seems to be a theme with her. The attorney next appointed to represent Sarah was named Winston Hobson. At a status conference in December, he told the judge that he had a banker's box and a half of discovery to go through. So, not quite the 6 boxes Sarah tried to sell us on previously. Sarah's last letter to Judge Wooten before this had suggested that he should be rotated off her case, and apparently by coincidence, Judge Wooten was rotated off her case, and a new judge named Judge Kranick was appointed. Fun fact, some years ago, one of Sarah's brothers got into trouble. Multiple kinds of trouble, ranging from controlled substances to having too many stray cats, to being inappropriate with a person who was underage, to urinating in his yard in view of his neighbors. The judge who sent him to prison was Judge Kranick. I don't know if Judge Kranick has made the connection. I feel certain Sarah hasn't, or we would have heard about it. Her next letter was written on January 19th, 2024. Honorable Judge Kranick. Finally, a new judge. It's strange how the Lord works, as I was in the process of trying to disqualify Wooten after being my judge 4 years, and me still incarcerated with nothing to show other than seven different attorneys, not by choice, news clips of me walking in and out of the courtroom, and everything relative to my case permitted to be slathered on the global internet, and in which I have not seen myself. We're slathering her case across the internet, are we? I think it's interesting how Sarah resorts to religious speech when she wants to kiss up to someone. It makes me wonder about her upbringing. The purpose of this letter is to introduce herself, as she wants to be seen, and we all know how important that is to her, to the new judge. I wanted to bring to your judicial attention the following information so you and the world are aware it is not I who am ever delaying trial, as Wooten inappropriately accused me of doing in a past hearing, especially now you have mandated a trial date to be had in May, with no further continuances, leaving less than 4 months to put together and complete what should and could have been done already. What happened in all the 4 years prior? Please see my correspondence online. I love the way she complains about her information being online and then immediately says, yeah, I've already written about all this stuff. Just read my letters online so I don't have to explain again. To date, Winston E. Hobson has been my court-appointed attorney for 133 days and counting. To date, Mr. Hobson has only met with me 1 time for a total of 3 hours, November 7th, 2023. 7th verse, same as the first. Good grief, Sarah. She again claims that this lawyer's phone doesn't work either. Somehow she just keeps getting lawyers whose phones don't work. And she's mailed him 5 letters. To date, I feel I am not being included or heard or cared about in my case, again, from the continued miscommunication, again, with Mr. Hobson, and time-consuming, undiscussed entries are being made on my behalf. The continuance I did not know about, the waiver of appearance I did not know about, along with other documents, and I never sent copies of anything filed, so I know. All of this reads like a bad rehash of everything that's come before. Instead of taking the opportunity of working with a new judge to think about what really matters and set a new tone, she's just testing him to see if he'll be more open to hearing her complaints than her last judge. She wants the same thing she always wants, to receive multiple copies of every single document ever filed in her case, to see her discovery, and for her attorney to devote all of his time and attention to her. She's upset that she wasn't at a pretrial conference the week before. I don't know why she isn't being included in these meetings. She's correct that it's her legal right, but in the same way that her claims that all of her lawyers' phones mysteriously don't work, something about this doesn't make sense. I'm still here, waiting patiently and very excited to get this highly anticipated show on the road. I await your overdue and very needed judicial direction, supervision, and intervention. Thank you in advance, Judge Kranick. Welcome. She's back to referring to her trial as a show, and a highly anticipated one that she's very excited about. I don't think she's trying to delay the trial. I think she just can't get along with anyone or listen to reason. This ending, welcome, is also just really dramatic. Like, welcome to my world. That's how I hear her saying it. Along with her letter, she included a draft of a motion to be included in and allowed admittance to all defendants' pretrial conferences and hearings. This is interesting. She's copied the formatting and style of an actual motion, and she's made an argument and cited a relevant law. She's even included a certificate of service at the end. I think she wrote this not just to get what she wanted, but to show Judge Cranick that she's just as smart as him. She's basically saying, look, I can be a lawyer too. And that's going to come back to bite her. Thus ends Sarah Boone's 13th letter. I'm reading from Judge Cranick's June 2024 order discussing the history of the case and Sarah's 7th lawyer. On February 1st, 2024, Hobson filed a motion to withdraw due to irreconcilable differences, including but not limited to ethical considerations. On February 9th, 2024, a hearing was held on Hobson's motion to withdraw. Hobson addressed a number of issues as for the basis for withdrawing, including disagreements on legal strategy, on what can and cannot be done, a lack of resources, and defendant's demands make her difficult to work with, including defendant taking non-viable legal positions and being unreasonable. As to a key substantive defense, Hobson advised that the retained and undisclosed expert is not keeping with what defendant has in mind. The court outlined the overriding claims for withdrawal by Padilla, Bankowitz, and Hobson: adversarial relationships, lack of satisfaction, and inability to meet defendant's desires. The court found that all of defendant's relationships with court-appointed counsel have deteriorated such that defendant and the court-appointed counsel cannot work together. The court advised defendant that although defendant has a right to court-appointed counsel, that right is not unlimited. The court twice advised defendant that defendant may not be provided another court-appointed attorney, and that defendant would have to represent herself if circumstances similar to Hobson's motion to withdraw occur. The court further advised defendant about the dangers of self-representation due to defendant's lack of legal training and knowledge. Defendant never stated that she did not understand that she may not be provided another court-appointed attorney. The court granted Hobson's motion to withdraw and appointed Patricia A. Cashman and attorney number 8. The court is aware of Cashman's extensive experience representing criminal defendants as both an assistant public defender and in private practice, including representing defendants accused of M, and is widely known to be able and willing to deal with and manage difficult clients. Peter, from The Lawyer You Know, says that if you read between the lines, what Hobson was likely trying to tell the judge without actually saying it was that Sarah had asked him to do something illegal. It probably wasn't quite as dramatic as it sounds. I'm not sure what it would have been, but I don't think she was expecting him to go and take out witnesses or something. Regardless, Hobson wasn't going to do it, and good for him. Sarah's new attorney, Patricia Cashman, is awesome. I read an interview with her, and she's just terrific. Plus, she has decades of experience. I would feel incredibly lucky if I got arrested and she was my appointed attorney. Sarah and Cashman seemed to be doing all right for 6 months, at which point Sarah sent the granddaddy of all letters, a 58-page missive, complete with cover sheet. It's actually a cover sheet, 2 letters, and what I'm going to call the packet. She's now writing in different fonts and really seems to be enjoying the graphic design elements of letter writing. And after 4 years of printing, Sarah has switched to writing in cursive. Why? What does that mean? I have no idea. She still prints when she rage caps, though. The first page is almost entirely bullet points listing things she isn't allowed to do, all of which complete the question, why can't I? I'll read some of the more interesting points. Why can't I have a bond? Have a complete download of my phone? Be respected for who I am truly, especially by my attorney, and not be disrespected for the mutated, malicious M all the world has falsely, incorrectly created and believed me to be. See all and know the same as the world can and does, including my attorney, from all the phenomenal, non-permissive amount of my entire case being available online globally before my trial, and most important, before I have seen myself. What doesn't anyone know already about my case? How about my side in everything about everything? Be correctly understood that I am not the problem for reasons I am on malappointed by the court attorney number 8. I think she meant malapportioned, not malappointed, which isn't a word. Then she switches to a new question starter. Why won't my attorney, for specific complaints about Miss Cashman? Why won't my attorney give me an honest answer? Show me everything she says she has and finished reviewing for my case, but withholds from me after I ask repeatedly for and about. Give me an answer other than, I'm putting this to rest. That's not necessary. Or, I'm not having this conversation with you. If Cashman's saying those things, it's probably because Sarah's demanding something she can't have for the 50th time. Let's think about the likely context of those quotes. I'm putting this to rest. That means the answer is no, and you need to stop bringing it up. That's not necessary. Again, this suggests Sarah is demanding things that are either not allowed or just unreasonable. A few weeks ago in court, we were all appalled by Sarah's motion to be allowed to have professional hair and makeup people get her ready every day before court. I suspect that's the kind of request Cashman would have refused to make. I'm not having this conversation with you almost has an unwritten again at the end of it. It sounds like Sarah has just been peppering this woman with the same demands over and over, and Cashman is saying no, and Sarah can't handle that. Then Sarah adds, why won't my attorney reassure she's on my side, for me, not against? This is very Chad Daybell. Essentially, what Sarah wants is a guarantee of loyalty. What is it with narcissists and loyalty? Why are they so afraid that people are secretly working against them? What reason would Cashman have for betraying Sarah? She follows this section up with more rhetorical questions. Why does my attorney and all the world think my case is already over? No one thinks the case is over. We're all well aware that this case is still going on. What she's upset about is that no one has any faith she'll be exonerated. And that's just not realistic. The case against her is incredibly strong. The next section contains the word conduitly, which isn't a word, and I have no idea what she was trying to say when she used it. Your Honor, during our first introduction at my last withdrawal of court-appointed attorney number 7, Hobson, you stated to me your uninvolvement with any of my letters I write. I am still going to write my letters, as conduitly they are to the world where all my potential jurors are located, and this is the only way anyone, including yourself, knows the very necessary insight to my continued disadvantages, hindrances, impediments I am still experiencing, on top of the new, spurring my intentions to write. The race to the pulpit is unfair, and it is important to me that you are aware and understand what transpires when the news cameras are off, and we're all in between my status hearings. To race to a pulpit is to try to be the first to publicly tell your story. Sarah is upset that she didn't get to tell her side first. Her priorities are protecting her reputation by telling the version of the story that makes her look the best. I think it's amazing that she says that Judge Kranick and all the potential jurors need the very necessary insight into what she's dealt with. Necessary for what? 2. As so many of the advantageous embezzlers, racketeers, mindless lemmings, and just altogether mean people can use their freedom of speech, not knowing me in any way other than what's being said by all the other mean people and being said in incredibly incorrectly, so can I. I assume she's talking about YouTubers again. I don't quite understand in what way I am embezzling or in what way discussing the contents of her letters is racketeering or why I'm a lemming. But as we're going to see, in addition to the thesaurus and the Merriam-Webster dictionary, Sarah has gotten a hold of a legal dictionary. She complains about the detectives on her case, saying that Copesel falsified documents and Lowen wore his sidearm during their interview, the former of which isn't true and the latter of which is. It's also not illegal. She implies that they tried to feed her a story. Personally, I don't think she worked with great detectives. I think any good detective could have gotten a confession out of her in under an hour and saved us all this mess. Why am I still not being included in my case? How much more of my case and self is being added hourly, especially after this letter gets loose to the internet, increasing the mass infection and destruction of my hopes to have a fair trial, anything fair, my side foremost, and wondering now if my attorney drank the punch like everyone else. These are exactly the same things she's been complaining about for years. She was at her most recent pretrial conference, and yet she's still complaining that she isn't involved. Is she in denial about the fact that the way she wants the justice system to work isn't the way it works? Why can't she accept that she isn't going to get what she wants? She's had 2 judges and 8 lawyers, and all of them have told her the same thing. You can't have complete control over your case. That's not how this works. Why can't she accept that? I'm not a psychologist. I don't know what the name for this is. I'm going to call it malignant tenacity, because there does come a point when a person has to accept something they don't like. And if they can't do that, it can really have a detrimental effect on their life, as we're seeing with Sarah's. All aforementioned reasons, and so many more, for this letter to be written, hoping to deter some of the unfair, one-sided finger-pointing at corruption and malpractice being directed at me only by those in the justice system who are trying to deflect the shame and shock from me fearlessly challenging the status quo. And it must be so because it's in my face on the computer at the same time on my boob tube television, brainwashed ignorant followers of disbelief, conformity, and greed, trying unsuccessfully to make it my life by character assassination seem worse than theirs. Know, too, that when anyone points their finger, 1, it's impolite, and 2, 3 point back at you. How many tried it to see? Put the stone down, as there will be no casting of anything today, except maybe for the role of my part for all the pre-conclusioned documentaries and crystal ball real-life stories of true crime incorrectly formulated from everyone supposedly knowing me and judging who they think I am, what really happened, and is going to futuristically. Remember, 3 point back. Soothsaying is not a real job. The court of public opinion is more important to Sarah than the actual court, and I don't think that she understands how little they have to do with each other. She loves this image of someone pointing at her and accidentally pointing back at themselves with 3 fingers. Then she includes this fascinating little story. To sum it up in the words of my attorney after I told her to Google me, she stated, "There's a lot." To sum it up in the words of myself, the defendant stated to my attorney after she stated that to me, "When can I see?" Okay, so to take this out of Sarah speak, what happened was Sarah told Cashman to Google her, and Cashman said, "There's a lot," meaning there's a lot about you on the internet. And Sarah's response was, "When can I see it?" She wants to see everything written about her on the internet. Why? Because she wants to see how famous she is. What she ought to be saying is, yeah, ignore that and let's work on my case. And I'm sure Cashman told her that realistically, the publicity isn't going to prevent them from finding a fair jury, which will be one of Sarah's complaints if she's convicted. I guarantee it. She's going to claim that the release of public records compromised the integrity of her jury. Then she adds, This is my case in every respect. Control, control, control. Also, I want to make it known I walked out on my attorney in our last meeting due to her unwarranted, uninformative, unprofessional, snotty attitude and her untruthful answers to my questions and beyond. So after literally years of trying to get someone to show up to meetings, now showing up isn't good enough and Sarah's walking out. Then we get to a larger quote about one of the parts of this case that made headlines because it is so insane. We have finally reached pretend judge. Also, I'm not sure why this sentence begins so much. It doesn't make any sense in context, just ignore it. So much I presented my solution in order to coexist with and work together in a hopeful, progressive, positive, appropriate manner. I added pretend judge to our interactions so she could calm down and ease up on her condescension, offensive demeanor, and obvious prejudgment. She seems, like everyone else, not to remember I am innocent until adjudged otherwise. She treats me as if I am not. After my introduction and explanation with pretend judge in the room or on the phone, I am trying to help her understand how she is making herself extremely unwelcoming. When in front of a real judge and in the courtroom is how she should treat me, her client, at all times. What Sarah did was introduce an imaginary judge who could preside over her meetings with Cashman. And each time Cashman said something Sarah didn't like, she would ask Cashman if she'd say that in front of a real judge. Patricia Cashman has 40 years of experience, specifically as a defense attorney. She doesn't need a pretend judge to oversee her interactions with clients. I should feel secure, highly confident, proud in her representing my life. I do not, and have said to her many times regarding her monumental disbelief in me and my case, which I believe contributes greatly to her inimical attitude towards me. I am hoping by this letter she will pick up the sword of injustice and fight alongside, not against me, as so many unmotivated, overwhelmed, weak attorneys prior, who bowed out ungracefully and crept away from the battlefield unsuccessful. This paragraph is fascinating to me. An attorney doesn't represent their client's life, and they aren't a therapist who will make their client feel secure, confident, or proud. What Sarah wants is some kind of crusading public relations therapist who can also manage her legal case. The imagery again references knights and battles against injustice. It's all back to the Lancelot thing. Sarah says that Cashman has monumental disbelief in Sarah and her case, but I suspect what that means is that Cashman says the legal strategy Sarah wants to pursue either won't work or just isn't legal. My case equals bizarre, equals unknown, equals different, equals ignorance, equals misunderstood, equals unfair. This does not mean my case can't equal success, and in more than one way. While everyone continues to ring their bells of malevolence, I am ringing mine of hope, honor, plausibility, boldness. Listen, I am not an M. The justice system should equal fair, faith, trust, respect, innocent until and if adjudged otherwise. 3-point back. This section is just Sarah spitting out whatever is left in her brain. A lot of her letters end with these brain dumps where she randomly says whatever she couldn't find another logical place to write. I don't know what the bells of malevolence are. She has used the bell metaphor before. But why is she ringing her bell of plausibility? That suggests to me that what she wants to put forth isn't the truth. She's not ringing her bell of truth. She's ringing her bell of plausibility. What can I convince you of? What will sound good enough that you'll believe me? That's the bell she's trying to ring. Beneath her signature, she added this: "Confused cat meme. Yes, thank you." And there's a heart. I think this is some kind of coded acknowledgement of some of her supporters, like a small, poorly hidden Easter egg. Either that or she's lost her mind and she thinks she just attached a cat meme to an email. Now, along with letter number 14, Sarah included a letter written 3 days earlier on June 4th, 2024. But she starts by referencing the letter she's going to deliver to the judge on the 7th of June. Is she post-dating these letters? It's very confusing, and I don't know what to make of it. This letter's primary complaint is that Cashman expects to discuss her case over video calls. Apparently, these calls are conducted in the open dorm that Sarah shares with 62 other women, but these were just update calls. Cashman visited the jail in person for longer discussions. "I have explained to my attorney numerous times previously in writing and verbally that despite the noise level, I do not in any way feel comfortable having in-depth private meetings regarding my entire criminal case on the visitation box, where there is no privacy whatsoever, and held in an open bay dorm with more than 62 other interested all years inmates. I cannot fully participate, if at all, from the entire dorm, officer included, trying to participate also in my case." At first glance, it seems like this might be a reasonable complaint. But when you think about it, it isn't reasonable. Previously, Sarah complained at length that Bankowitz wasn't even showing up to video visits. She was upset that he wasn't scheduling them. I think she's the type of person who, as soon as she gets what she's asked for, demands more. She got the video visits, but now she wants exclusively in-person visits in a private room, apparently. And she's mad that everyone can hear what they're talking about, but she claims all of her case information has already been shown to the entire world, so how much does it really matter? Even though Judge Kranick appointed Patricia Cashman specifically because she's known for being able to get along with difficult clients, Sarah can't make it work with her either. She gives this amazing description of a contentious video call they were on. "As always, my attorney did not listen or care after I repeatedly tried reminding her of my unsecure environment, barking at me I can listen or not, still going, over-speaking, and not at all allowing me to respond. After repeating to her over and over and over, while she's beginning to speak louder and over me still, to please schedule an in-person meeting where all can be discussed further, privately, with no success of being heard, I disconnected the visit telephonically. She uncooperatively. She is impossible." I can imagine this so clearly. I'm sure Sarah had her fingers in her ears and her eyes pinched shut and just kept saying, "In person only! In person only!" She, like other former attorneys who always blamed their dysfunctions on me, said, "You don't like the answers I give you." What answers? See pages 1, 2, and 3. "I am not the problem, except that I want to and should be treated fairly, with respect, acting more professional than the paid, I've been doing this for over 40 years, professional." Except that Sarah clearly is the problem. Yes, 4 of her lawyers withdrew for reasons that had nothing to do with her, but 4 others withdrew because she was impossible to work with. That's not bad luck. That's not coincidence. Also, it sounds like Cashman has been telling her things she doesn't want to hear, and that the issue is with reality. Sarah's fundamental problem is with reality. Multiple attorneys have now implied that she's putting forth non-viable legal strategies and asking them to do things that they simply aren't allowed to do. But Sarah continues to believe she's smarter than everyone else and somehow knows the law better than any of her 8 attorneys. It's like she thinks she's some kind of legal savant. All attorneys, do you remember why you even wanted to be one? Remind yourself. I feel like this is somehow connected to her desires for a valiant lawyer. She wants a crusader who's going to fight for her at all costs to themselves. She claims that she's discriminated against because of the charges against her. No one listens, and it works in everyone's favor but mine. That I am an M stuck in jail so they can pin on me their uninterested, unmotivated, hopeless, they're going to believe me over her haughty attitude. I am not wrong for not thinking less of myself because everyone else has and does this present attorney foremost. I find it unlikely that Cashman told Sarah she had to think less of herself. You need to lower your self-esteem if you want to get acquitted just doesn't ring true. Also, Sarah really loves the word foremost, does not know what it means or how to use it. She did hear Judge Cranick threaten not to give her another lawyer, though. And representing myself is not an option, as both judges have now threatened me with from being outspoken and intelligent in all my observations of the ongoing mistreatment I am and have experienced. I have no new experiences from it always being the same. Blame Boone. I refuse to be moved in wanting respect, no matter who everyone thinks I am, clarity, inclusion, honesty, and professionalism. It's interesting how she takes everything so personally. Next, she complains about how much information is available about her online. Florida sunshine laws provide access to a wild amount of info, I have to admit. All of the jail's staff notes about her behavior can be accessed, and even things like what she's purchased from the commissary, which is how I know that we both enjoy hazelnut coffee. And another great reason not to have my case meetings on the public visitation box is my personal, confidential inmate information, such as my visitation lists, 2020 through 2023, with names, etc., my interactions with inmates and officers, what I eat, when, my personal jail calls also being thrown online. For what? To hate me more or try to get others to because I don't eat breakfast or because I know some Latin or have short hair, my penmanship is nice, or because I'm not getting fat and sleeping all day, but rather fully applying myself, fighting still, making everyone upset from not having to fabricate, mutate, splice, edit. The world apparently knows all. What's next? How many times I go to the bathroom and what function I perform? No, please don't tell us that. No one knows anything, nor seems to want to, from being comfortable in their corruptions and striving to be on top with ratings, web hits, and money. My case details, if anyone forgot, and if you think about it, all that keeps getting plastered and plagiarized, posted, and poked fun at about me. It's all in my favor, proving myself right about all the mindless lemmings, shut-ins, the justice system, advantageously mistreating and profiting from everything in my case, before my trial and before I've seen. This is the second time Sarah Boone has called me a lemming. I'll take it. When can I win? In anything. It's coming. I am not the problem. And if anyone were to slip on my slides and have to experience, tolerate, deal with any of what I have and am, would bravely be doing the same. She thinks it's brave that she's fighting with her lawyers this much, and that she's eventually going to triumph over them and win. Her belief that she isn't the problem is beginning to border on delusional, if you ask me. She ends the letter strangely. Don't knock it till you try it. 3-point back. Race to the pulpit. Again. Always. Sarah Boone. She's really enamored with this image of the 3 fingers pointing back. I was planning on doing a different drawing for each of my videos of Sarah, but I got the flu last week and had to lower my expectations. I did do a drawing, though, of the fingers pointing. Don't knock it till you try it? Don't knock what? What is she talking about? Thus ends Sarah Boone's 15th letter. Included with the 2 letters were dozens of pages on which Sarah had copied passages from books and documents, which I'm going to refer to as the packet, because I don't know what else to call it. There are various long definitions from a law dictionary, excerpts from the Declaration of Independence and the Florida Constitution, some maps that she's marked. At first, I thought that maybe she'd written all of this for her own edification and thrown the pages in with the letters in order to make the envelope thicker and somehow more important. But then I noticed that all of the topics were somehow related to issues Sarah has raised in her letters. It turned out the maps were marked with every city from which she'd received fan mail, as she calls it. So I thought, okay, she's being condescending again and telling Judge Cranick that he needs to review these concepts, and that's why she's writing the definitions. Like, she starts by quoting Florida's rules of criminal procedure, and the section she quotes has to do with her right to see her discovery. She includes 9 pages of quotes regarding discovery. Then there's a page about pretrial conferences, followed by 4 pages about how attorneys are supposed to behave. So I thought she included all of this to justify her demands, but as I kept going, I realized that she chose the contents very deliberately, and taken together, they almost constitute an argument. You can read them, and it's very clear how Sarah's connecting these ideas in her mind. It's like she got all her sources and evidence gathered together. There's one page where she actually writes out how these quotes are relevant to her case. My former attorneys are withholding some of my case contents I have supplied to them and which have been deemed lost. Many other items have been returned, not to myself, but to the next attorney, and which have been unable to be located to date. I mean, it sucks that her lawyers have misplaced things, but that's not the same as withholding them. What's really wild to me, though, is that a lot of what's in the packet is directly relevant to the defense that she seems to be trying to put forth. She includes the definitions of duress, interrogation, custodial interrogation, all of which point to issues around her police interviews, and sure enough, she tried to get the police interview thrown out. She photocopied US and world maps and drew stars on each of the states and continents from which she's received letters, apparently in an attempt to prove that the publicity has hurt her case. So I guess she's already preparing appellate issues. She writes out dozens of definitions, many of them legal terms like prejudgment. She also includes a lot of information about excited utterances. I'm not sure how those would play into her defense, but I'm keeping my ears open during the trial. But the funniest part is that she ends the packet with the definition of the Freedom of Information Act, which is, of course, how all her letters are being made public. And she tries to argue that their dissemination was illegal because it ruined her chances of a fair trial. Why did she send this to Judge Cranick? I mean, there's no sensible reason. She knew it would all be made public and that the prosecutor would read it. Why reveal her thinking and give so many hints about her legal strategy? I'm gonna guess that she just couldn't resist. I think she sent all of those pages because she wanted to blow the judge away, and the prosecutor, and probably her own lawyer, with how smart and clever she is. It's possible that she believes she's so much smarter than everyone else that she thought Cashman and the prosecutors wouldn't understand what she was implying. A couple months ago, I was talking about this case with Gosha, and he said, "Wouldn't it be funny if Sarah was deliberately delaying the trial so she could use the jail library to give herself a complete legal education?" I don't think she's trying to delay the trial, but I do think she believes she's smarter and cleverer than her lawyers. I also think she sent this as a warning that she believes the way she's being treated is illegal, and that she'll be able to bring everyone down with her superior understanding of the law. After all, it's almost her chance to win, as she put it. I don't think any of this went over Judge Cranick's head. He has a very quick mind. I don't think much gets past him. I think Judge Cranick recognized this pile of papers for exactly what it was. Sarah congratulating herself on being smarter than everyone else. There's one other thing I want to mention about the packet. My initial belief was that Sarah was writing frantically and was too impatient to proofread her letters. I thought that until she mentioned that one letter was a second draft, and then I entertained the idea that she might be writing second drafts of all of her letters, although she still wasn't proofreading them. The packet, however, has further muddied the waters. There are almost no typos in the packet. Maybe one a page. Maybe. This makes me think that my first theory was correct, that she's writing these letters so maniacally and with such a scattered mind that she's composing sentences in which the beginnings don't match the ends, words are missing, words are misused, words are invented, and she's basically using them as emotional dumping grounds. Thus ends Sarah Boone's packet. The same day that Sarah wrote the cover letter to this mess, she turned her June 4th and June 7th letters and all the assorted definitions and excerpts and maps into the judge at a status hearing, where she was present. Judge Cranick described it thusly after the fact. Defendant advised the court to walking out of at multiple meetings with Cashman, which was confirmed Cashman, utilizing a pretend judge to oversee defendant and Cashman, launching multiple attacks on Cashman's professionalism, and providing the court with letters dated June 4th, 2024 and June 7th, 2024, and both of which were filed on June 21st, 2024. Cashman advised to her efforts and time spent on the case so far, 20 hours. Cashman addressed disagreements on legal strategy, including defendant attaching importance to issues that may not be legally important. In riposte, defendant accused Cashman of lies and half-truths. On June 11th, Cashman moved to withdraw. In letter number 16, Sarah tells Judge Cranick that she learned from a jail officer that Cashman had moved to withdraw. Unsurprisingly, Sarah's mad that no one informed her. Judge Cranick, I am trying to receive, please, a copy of her withdrawal to better understand her reason for the undisclosed departure from my case. No attempt was made on her part to solve or remedy in some type of discussion professionally beforehand. Therefore, I am having to include you for this request, as I did with my most recent letter. She spends the rest of the letter complaining about the fact that she still hasn't personally reviewed all of her discovery and asking how she can get copies of it. Thus ends Sarah Boone's 16th letter. On June 28th, 2024, Judge Cranick ruled that Sarah Boone had, through her behavior, forfeited her right to court-appointed counsel, and he wrote 16 pages explaining why this was the right course of action. In one passage, he wrote, Defendants' recalcitrance to the attorneys who were not conflicted out, Padilla, Bankowitz, Hobson, and Cashman, antagonism, hostility, and attacks on the professionalism of Padilla, notably over a year after the fact, see footnote 9 above, of Bankowitz and of Cashman, and personal attacks on Padilla, Bankowitz, and Cashman. Each of these attorneys were required to withdraw. It has become apparent to the court that defendant will not permit herself to be represented by anyone. Later, he wrote, as of February 9th, 2024, the instant case had been continued 16 times. As of June 26th, 2024, this case has been pending 4 years, 3 months, 5 days from the date of the filing of the information on March 23rd, 2020. This is why I love Judge Cranick. He mocked Sarah Boone in his order forcing her to defend herself. He parodied her writing style. It's just... He was serious about not giving her another attorney, too. Actions speak louder than words, although defendant's words seemingly reveal a desire to go to trial. However, as set forth herein, her actions and inability to work with court-appointed counsel are repeated over and over, allowing defendant to her 8th court-appointed attorney, her 9th attorney overall, will only serve to delay the case further and encourage defendant to persist in efforts to prevent the resolution of the case on its own merits. I think he might have miscounted the number of attorneys she had, but that's something that has been a confusing issue for everyone involved. Judge Cranick said that Sarah would have to defend herself. She was still allowed to hire a private attorney, if that's what she wanted, but he refused to appoint anyone, and he made it very clear that no matter how late in the game she hired representation, he wasn't going to continue the case again. They were going to trial October 7th, come hell or high water. Only it turned out to be high water and he had to delay it one more week. That's not the point. And this is entirely Sarah's fault. Not just because she refused to get along with her attorneys, but because despite her protestations that she didn't want to be pro se, she kept trying to act like an attorney. She wrote out a motion and mailed it to the judge. She labeled her letter to Judge Dean as a motion. She copied dozens of legal definitions and strung them together in a loose, sort of abstract argument. She brought this entirely on herself. As you might have guessed, Sarah was not happy about being told she had to go pro se. She began her 17th letter by putting scare quotes around honorable in Honorable Judge Michael Kranick. She did it on the envelope, too, which I find hilarious. Then, when she wrote her case number, she wrote case number and in parentheses, 1 on many websites, and then put the actual case number. She's pretty much given up all attempts at being polite by now. Judge Kranick, where's my discovery? I am still waiting for you to provide me with the contents of what former attorney Cashman supplied to you and the court at the surprise status hearing held in secret on June 28, 2024 at 1:30 p.m. Apparently she didn't know about the hearing on the 28th, where the judge met with Cashman to discuss her motion to withdraw. I'm not even sure defendants are entitled to be at such hearings. Sarah's got a new symbol that she's going to incorporate into this letter, a clock. This is going to sound really incoherent at first, but it actually sort of makes sense by the end of the paragraph. Sort of. Your designated clock of unfair judgment ticks empty and incessantly while waiting for you to deliver. As usual, it's in your favor. In your nonchalant, relaxed, unconcerned attitude of me to receive, you are robbing me of precious life-saving time to fully and properly defend myself, on top of my already and still being violated constitutional rights and being forced to represent myself based on false information. Whatever self-control Sarah still possessed at this point, she seems to have lost it. She's upset that she's being forced to represent herself. She's upset that she doesn't have all her discovery. She's upset that she doesn't have a private office in which to review said discovery. And she's very angry at Cashman. Cashman, I'm glad I could help you shine in the courtroom in front of the judge by you personally and finally bringing everything I've been asking for since day one, and after I included you in my letter to the judge ensuring your return, unlike you who did not include me on your motion to withdraw. Surprise! And I had to find out from someone else, an officer, 3 days before this surprise status hearing, so you would even know what to bring. Why didn't you bring to any of your 20 hours of meeting with me? As always, it's in everyone else's favor but mine. So Cashman didn't spend 20 hours total on the case. She spent 20 hours with Sarah Boone, either in person or on video calls, many of which Sarah apparently walked out on. Also, according to Cashman, she spent 45 hours with Sarah in person. I'm not sure where this 20 hours is coming from. Then she goes back to berating Judge Kranick. Your time constraints are extreme and unreasonable. Your decision you claim to have considered from your order is illogical and unfair, specifically that it has been malformed by your ignorance and experience of my case, misinterpretations, straight lies from the attorneys appointed. They are brazen to stand at your pulpit in your courtroom and commit perjury to your face in the world. But yet, it's me. As Dr. Barry and apparently also the jail intake staff have pointed out, Sarah lacks insight. She's not unintelligent, but she's incapable of objectively examining her own behavior and realizing how much she is contributing to the issues in this case. She's going to refer to an included document here, and I'll show it to you in a moment. It's a help wanted poster that she made in order to attract an attorney to take on her case. While your clock ticks ceaselessly and loud as I wait for you to deliver anything, even more fingers are noticed. They really do point back, and I am defending myself against your inaccurate, libelous, I can write letters too order. Please, would you post my included document in your break room, wherever you think it may be seen and understood, unlike me in your courtroom? How about by the copy machine, where your JAs should have made me, the news crews, court TV, professional YouTubers, and photographers, the world, a copy of the notice of hearing where all aforementioned improprieties occurred and then some, including the drop-off of my case materials, said order being ordered, and me being pulled by my uniform to exit your courtroom while still trying to speak and defend myself against all the mayhem and chaos, especially the surprise at even being there unprepared and without notice. Oh, wait, my posting everything supposedly is public record, and there is no notice at all. Another it's in your favor moment. It's a group effort. Saboteurs. Surprise! I shall return. Nothing is impossible. Believe. Hopeful, grateful, waiting. Thank you for posting. Sarah Boone. Remember, please, Judge Kranick. Fair, neutral, impartial. You must be. Always. And here's the poster. Inmate seeks attorney. Looking for a prosperous challenge? Ready for your close-up on national television? Are you zealous with a side of keen? Show the world who you are with your original creativity, extraordinary expertise, confident ingenuity. Qualifications must include being trustworthy, honest, passion-driven, open-minded, exceptional problem-solving skills, client inclusion at all times, team orientation, collaboration, extreme efficiency in listening, communicating, understanding, dedication to success, possessing a winning mindset, capability of excellence in representation, committed, maintaining faith in the client and case with the ability to think differently, overcome all circumstances. Epic opportunity awaits. Sarah Boone, Orange County Corrections Department. Invest in the oppressed. Believe. I have to hand it to her. It's a great poster. I really think she missed her calling as a graphic designer. She's stuck in jail with nothing but pen and paper, and she came up with this. She has different fonts, she plays with font size and negative space, I like the stars, and invest in the oppressed is a fantastic hashtag. And she asked Judge Kranick to hang this in the courthouse break room. I don't know if he did or not. Thus ends Sarah Boone's 17th letter. Over the next 3 months, Sarah filed a number of motions, always identifying herself as Sarah Boone pro se indigent defendant. Among the motions, there is one other letter, and I'm just going to read a bit of it. The letter was written in August of this year, and it's addressed to the captain of the jail staff. Basically, it's Sarah laying out all the stuff she wants. The tone is surprisingly polite. I don't know if Sarah actually respects Captain DiGiovanni, or if DiGiovanni just hadn't done anything to tick her off yet. Captain DiGiovanni, thank you for your timely cooperation and assistance in me receiving my laptop yesterday, August 6th, 2024, and 2 Discovery USB drives supplied by my investigator. I am attempting to fully maximize my opportunities available from the Orange County Correction Department to thrive in my forced position as court-appointed pro se defendant and the success of my case. I want to excel in my present circumstances by attempting my best and have been since day 1 of my incarceration ongoing 5 years ago. As you can imagine, I do not want to be here any longer, ever. With the hopeful, effortless cooperation and attentive care from yourself and OCCD, I believe I can achieve more, efficiently, effectively, equally, so I am able to plan my very overdue exit in the very near future. She can't stay polite, though. And even when she's trying to be polite, she sounds paranoid. After asking that she be allowed 2.5 additional hours in the evening on which to work on her case, she writes, Number 2, USB drive security. As stated in court to the judge, I do not feel comfortable in handing over the entire contents of my case to the miscellaneous officer in the dorm for the day. All of my information is highly confidential, and I am trying to avoid further leaks on top of the already recorded jail phone calls, visitation names and details, my inmate interactions, meals consumed, etc. She claims that this very day, she went to get the laptop and discovered that someone had taken her 2 USB drives out of the laptop bag and put them in a separate bag. Apparently, this is evidence that the jail staff is secretly looking through her discovery. She says that when she questioned jail staff about the laptop and the USB drives ending up in 2 separate bags, they became agitated. I can only imagine that means really, really annoyed. Then she demands to use the classroom because she can't possibly work on her case in a room with other people. She wants headphones so she can listen to the videos and calls in her discovery, which would be reasonable if she weren't also requesting an entire room to herself. She wants internet access and a word processing program, the latter of which I actually do think is quite reasonable. She wants access to a phone and a phone line so that she doesn't have to collect calls, which is probably also reasonable. And she wants hard copies of her discovery so that she can work on her case at any hour of the day or night, which seems less reasonable given that she's in a dorm room with 60 plus other women and can't just go flipping the lights on at 2 a.m. As she has many times in her letters, she stresses that something wasn't her choice. Becoming pro se defendant was not my choice. I am already trying to overcome extreme circumstances just in my life of incarceration, and now, in addition, being forced by the court to represent and defend myself in my criminal case. Extreme has progressed to extraordinary. She's really developing an affection for alliteration, which is kind of fun. She seems to think this absolves her of something, but she was literally forced to go pro se because of her own bad behavior. Sarah's inability to see how she contributes to the problems in her life is profound. She has no self-insight. Naturally, as she gets toward the end of the letter, she decides to just slobber all over Captain DiGiovanni. Please understand my attempts are always in good faith, where I'm simply trying to complete these tasks needed to surpass my difficulties and achieve overdue success. And finally, I cannot do it without you and the assistance of the Orange County Corrections Department. And then at the end, she CCs Judge Kranick. Thus ends Sarah Boone's 18th letter. Unsurprisingly, the poster that Sarah made and asked Judge Kranick to hang in the courthouse break room brought even more publicity to this case, and in an incredible twist of fate, it worked. The poster worked. It was featured on Court TV, the same channel Sarah claimed wasn't a real news network in a previous letter, and was seen by James Owens, a Florida attorney, and he got in touch with Sarah Boone. Initially, he was only interested in helping her negotiate a plea, but when that fell through, he let Sarah rope him into representing her, despite several reported screaming matches between the two of them during his jail visits. I once heard someone say that people choose lawyers who are similar to them in personality and character. That was certainly true in Chad Daybell's choice of lawyers, and I suspect it may be true in Sarah's as well. So far, he's tried to get her police interview and all her phone data thrown out, and he's tried to convince the judge to let her have professional hair and makeup applied. While Judge Kranick said that that wasn't going to happen, Owens argued that she should at least be allowed to have members of his team doll her up in the courtroom, and the jail staff stepped in and said it would be too easy for her to pocket a mascara or an eyelash curler. Meanwhile, Sarah's at the defense table using her lawyer's iPad. There's one more example of Sarah's obsession with how she's seen that I can't resist discussing, even though it's not in her letters and wasn't even written by her. This is from the jail's inmate behavior notes. Unfortunately, this was printed in very tiny type. This note is from August 14th, 2024. While inmate Boone appeared for her scheduled court appearance, it was discovered by CRSO Jones that Boone had altered her county-issued blues with staples along the seam of her pants legs. Inmate Boone was counseled for this negative behavior and informed that her blues were considered contraband and issued more blues. But that wasn't the last of it. On Friday, August 16th, 2024, inmate Boone, Sarah, requested an extra small uniform shirt verbally, also inmate request form. Inmate Boone complains that the small uniform shirt issued to her has an improper fit, too big. Inmate Boone complains the small uniform shirts are revealing. I contacted Uniform Supply. I was informed the smallest uniform shirt is a small. Inmate Boone requests to receive an extra small shirt prior to her meeting on Saturday, August 17th, 2024. Then there's a further note. On August 16th, 2024, inmate Boone requested a smaller inmate uniform top due to a meeting scheduled for her case. I asked inmate Boone what size top did she currently have on, and she informed me as small. I informed inmate Boone that size small was the smallest inmate uniform top that FDC had to offer. Inmate Boone requested that I look for her a different small that may fit smaller than the small that she was wearing. I informed inmate Boone that I would not look for her and smaller small. She was informed to wear a t-shirt or a thermal under her top if she felt it was too big and might show too much. She wants that jail uniform tight. And she's going to keep bothering people until she gets a smaller size. And if no one makes a smaller size, she'll make one. Even though Owens only came on the case 45 days ago, Judge Kranick, God bless him, has held to his word and refused to order a continuance. Sarah's trial officially began after 4.5 years and a 1-week delay for the hurricane on October 18th, 2024. Those of you who watched my Chad Daybell series know that I like to end my videos by considering 2 questions. How could we have made this document better? And what have we learned about the author by reading it? I'm going to continue asking those questions because I think they're still relevant. One more than the other. First, the not that relevant question. How could Sarah have improved these letters? Well, let's think about that from a technical standpoint. The most important thing she could have done was reread them. I don't know if she was writing rough drafts and copying them all the time, or if some of these are rough drafts, but all of the letters are slathered, as Sarah would say, with typos and omissions. Many of her sentences just aren't sentences, and not in a good way. More importantly, the way she speaks to people works against her getting what she wants. You can't spend 7 pages telling your judge what a useless hack he is and then ask for a favor. Her letters drip with loathing and condescension, and that simply isn't an effective technique to use in what is essentially a persuasive argument. She wants help from the judge and from her attorneys, and if she had politely, respectfully, and briefly stated her case, I think her letters would have been much more successful. Instead, she sort of used them as vessels into which she could dump her most negative emotions. She's just crapping all over everyone and then sending it through the mail. What have we learned about Sarah? We've learned a lot about Sarah, and not all of it bad. We've learned that she's creative, sometimes funny, occasionally clever, and she has a strong visual sense. But all of that is overshadowed by how impossible she is. She's stubborn to the point of becoming irrationally rigid. She's controlling. She has a massive victim complex. She's bitter and sarcastic and will not hesitate to attack people personally, projecting all her fears and anxieties onto them. She's sloppy and careless and lacks attention to detail. I don't know what personality disorder she has, but I feel pretty confident saying it's at least one of them, maybe more. Based on these letters, there seem to be two things Sarah values above all else: control and her reputation. Even in the letter she wrote to Judge Dean about how she felt her ex-husband was mistreating her and poisoning her relationship, her only focus was on herself, how the situation was affecting her, how no one cared about her. There was nothing in there about how the situation was affecting her son. Nothing about what was best for him or what he needed. Her single reference to George makes him sound like they were strangers. Everything in Sarah's world revolves around Sarah, and because it's all about her, she thinks it should all be within her control. Over and over, we see her demonstrate how concerned she is about her reputation and the opinions of the outside world. She wants to be in control of that narrative. She wants to control what information about her gets out so she can control how people see her. And she has a wildly inflated sense of her own importance. That's why she thinks the entire world is hanging on her every word. I'm speculating here, but I'm going to guess that one of the things she argued about with all of her attorneys, including the one she currently has, was about her testifying. She should not testify. It's not going to help her case. But I suspect that's something she's always insisted on because she has this driving need to be seen and heard. She also seems to believe she can talk her way out of anything. It hasn't worked for her so far. I think she's delayed this trial until she could be in control of every part of it, not because she's afraid of the trial herself. Clearly, she can't wait to get to trial. Her letters repeatedly refer to it as a show and reference how she's going to tell the world her story. She wants the attention, and she continues to insist that court will go well for her because she isn't capable of looking at herself and her behaviors objectively. She can't even understand that if she spends 6 pages of a letter railing at someone and attacking their character, they aren't going to believe her when they reach that last paragraph and she tells them how grateful for them she is. No one is buying that. And her defensiveness isn't going to help her out on the stand. She testified during a hearing last week, and the prosecution managed to get her flustered with their first question. She's going to fall apart as soon as she feels challenged because her ego is so fragile. I think it's likely that Sarah will be found guilty, but I could be wrong. Maybe there really is a convoluted, misunderstood secret truth waiting to be revealed. Stranger things have happened. It's obvious that Sarah is running the show, and that Owens is just doing whatever she wants. He's translating her demands into legal jargon and motions, and he looks like he has no idea what he's doing because so much of what he puts out there is ridiculous. Sarah wants to be the victim. She has a strange need to get others to take care of her, to do things for her. That's why she didn't want to represent herself, even though she thinks she's smarter than all her attorneys. So she's determined to be seen as the victim in her case. And that's why she's claiming self-defense, even though everyone else in the world looks at this case and says, how can leaving a man in a suitcase and going to bed be considered an act of self-defense? In order to make herself appear to be the victim, she's going to throw George under the bus. She's going to accuse him of awful things that never happened, like that he threatened her dogs, even though she said in her police interview that he was playing with the dogs and loving on them the day he died. She's going to accuse him of SA, which is despicable. I'm sure she spent the last 4.5 years thinking up things to claim he did, each more disgusting than the last. But no one deserves what Sarah did to George. Even if every single thing she comes up with to say is true, her response was unacceptable. You don't do that to people. I keep thinking of that image of the finger pointing and Sarah writing, 3 point back. Yeah, Sarah, they do. And now you're pointing the finger at George. And guess how many fingers are pointing back at you? I have compassion for Sarah. Not because she deserves it, but because that's how I try to live my life. I try to give her grace, knowing that she's in a very tough situation. It's her own fault she's in that situation, but even so. I'm sure it's terrible being separated from your son and being the object of public ridicule and having so little control over your life. But even more than compassion, I have pity for Sarah, because despite the prosecution's rocky start, I think it's very unlikely Sarah will avoid conviction. And the prison she ends up in will probably make the Orange County Jail look like the Four Seasons. Sarah hates being in a cell. She refused to move out of the dormitory and into a cell, even when Judge Kranick offered to let her keep all of her printed discovery in there with her. She didn't like the idea at all. The idea of a woman who confined a man to death being forced to spend years on end in a two-person cell is fitting, I suppose. But what will be worse for Sarah is that she'll be forgotten. Her reputation will never recover. She'll be globally known as an M. Her son and Brian will probably never speak to her again. She won't be anyone's priority. And she can, and will, I'm certain, continue writing letters, but no one will be posting them on the county clerk's website. No one will be reading them on the internet. There will be other shocking crimes with depraved, outrageous perpetrators, and Sarah Boone will be reduced to a true crime footnote. That was supposed to be the end of this video, but when I was lying in bed at 4 this morning, unable to sleep, I felt like I finally started to understand how all these pieces fit together. I kept coming back to the way Sarah keeps trying to get people to take care of her. Right after she was handcuffed near the end of her police interrogation, she tells Detective Lowen that she desperately needs water, even though we saw her drink multiple glasses of it during the interview. She asked the first officer on the scene for water too after George's death. And maybe she is chronically dehydrated. That could be due to alcoholism, I suppose. Or maybe she just gets thirsty when she's anxious. I mean, she did break down and drink from the hose outside her apartment during the investigation, although I thought that was quite possibly a manipulation tactic to put pressure on the officer. But the fact is that every time she senses a threat, she begins to act needy and begs for help. And that means something. When the two detectives arrived on the scene, Sarah immediately told them that she was afraid George's family was going to retaliate against her. There's a clear pattern. The first officer arrives on scene, an obvious threat. 2 detectives arrive, an even bigger threat. She gets arrested. Now she's been fired upon. So she asks for water. For me, this makes it impossible to buy self-defense, because now we know how she behaves when she feels threatened. If she'd thought she was in danger from George, she would have asked him to get her a cigarette or a Dr. Pepper or told him she didn't feel well. And I'm not saying that if her early attempts to garner sympathy didn't work, she wouldn't have escalated to violence. That seems entirely possible. I'm just saying that it's obvious Sarah's first response to a threat is to act helpless and needy and try to gain sympathy. And then I remembered why I made these videos in the first place. The letters. Her self-obsessed, madcap, voluminous letters, the texts of which fall into 2 primary categories: complaints and entreaties. She's either ranting about her lawyers, the judge, and the public at large, or else she's begging for help. I need this. How can I get this? Can you give this to me? The letters are Sarah's response to an existential threat that the trial represents. We've seen time and again how important public image and societal roles are to Sarah. I think there's a good chance she grew up in one of those narcissistic families where appearance means everything. I think Sarah was telling the truth when she said she was always a straight A student, and I would bet that's something that was seen as very important to her parents. I don't know where this information came from, so I can't vouch for it, but Criminal Intent ex Katrina Marie, who has a lovely YouTube channel, says that Sarah's mother went to nursing school after her husband died and was a straight A student. I think that tracks. I don't know what kind of childhood results in someone developing narcissistic behaviors and alcoholism and a needy, help me because I can't help myself threat response. But I would wager it was a difficult one. Maybe not materially difficult, but emotionally difficult. And it resulted in an adult who can't really function in the world. I doubt Sarah was getting her emotional needs met as a child. I'm certain she didn't feel heard. So she was growing up while making sure to appear perfect from the outside, But on the inside, she probably felt like she wasn't good enough. And that's a recipe for narcissism and narcissistic behavior. Narcissists have to convince everyone that they're the most incredible, brilliant, perfect beings, more angel than human, because on the inside, they feel deep shame and self-loathing. They bury that and focus all their attention on the image they want to present to the outside world. They can't take criticism because, being based on thin air, their inflated egos will collapse. That's why Sarah couldn't just admit to the police that she was drunk. She couldn't say, I'm a raging alcoholic and I passed out, and because of that, 3 young people will never see their father again. She has to maintain a flawless facade to excel at everything. That's why she didn't take the plea, even though she probably would have been out in 5 years or less. She cannot accept that she's an M. It would feel like wearing an actual scarlet letter to her. The charges against her are a huge threat to her self-image and her identity, and that's why Sarah's been writing these letters. That's why she keeps writing. She's screaming at the world at large that she's in danger and needs help. I think we've all wondered how she kept Brian so wrapped around her little finger, and it's probably because for many years he saw her as helpless and incapable, as someone who needed him. When George was arrested in August of 2019, he told the arresting officer that Sarah hit him all the time. This is from the police report. When I asked George what happened to Sarah, he stated, I do not know. When I asked how she got the marks on her neck, he alluded to the fact that he gets hit all the time and what is he supposed to do. When I said he should call the police, he said he would not call the police on her. I asked if he gave her the marks in self-defense. He said no. I asked if he hit her because she hit him, and he would not answer. So they arrested him. And incidentally, shame on the police for failing to protect George. Ever since I read that report, I've wondered why he wouldn't call the police on her. And I think the reason might be that she had him convinced that she was the victim. If not of him, then of her mental health, or her childhood, or her issues in general, or everyone else in the world. Brian, her former bosses, who knows? She's told us 1,000 times, though, that she's the victim. Always. And it sounds like George was a good guy who didn't want to add to her burdens, who wanted to take care of her and pay her bills and play with her kid for her. He had compassion for Sarah. He trusted her. It's tragic that following his desire to protect and care for her led him into a literal trap. I'll turn this video back over to me from 2 days ago now. I just wanted to add that. That is the end of the letters, folks. At least for now. We'll see what happens in the future. Maybe there will be more letters, and maybe there will be more videos before Sarah fades into obscurity. I won't have a new video out for a few weeks as I'm going to my agency's retreat. But then we'll finally talk about Chad Daybell's 2 books of religious advice for teens, which are full of revealing stories from his own youth. And a lot of bad advice. I'm glad I saved those 2 for my last video because they're a ride and a lot more fun than the end of that awful series he wrote. But if you've made it with me this far, please write in the comments what book you'd like to see me cover after we've finished with Chad and a little post-Chad surprise I've got planned. I'll give you 3 options. I can do Melanie Gibbs' nearly incoherent spiritual book, Feel the Fire. I can cover Jodi Hildebrandt's deranged self-help book, You Are Not Enough. Or I can do Julie Rowe's near-death experience memoir, A Greater Tomorrow. Let me know which you're most interested in. I'll put a poll on the community tab too. If you enjoyed this video, please consider liking and subscribing. Please don't reach out to anyone involved in this case. And remember to use your words wisely. Thanks. But also to show Judge Wooten how smart she is. Did I say Judge Wooten? Wasn't it Judge Kranek? After the... Oh, crap, this is a long excerpt. You stated to me, what is that? Oh, it's how she should treat me. We're all in between my status hearings. What does that mean? I think, how many, oh, the noise letter. I disconnected the video telephonically. She's uncooperatively. What? I can't handle this, Sarah, you're losing your mind. What? That I am an M. No one knows anything, nor seems to want to from being... What? What? I can't handle this. Visitation box. Shoot. I disconnected the visit telephonically. She uncooperatively. Right to her discovery. God, how long is this quotation? Holy shit. I can't read this. It doesn't make any sense. And increasingly. Increasingly? No. Okay. Connecting the ideas. Where? What? Where I am... Complains the small universe shirt. 20 through 2003. 20,003? Is that what I said? All right. So she's disturbed. Oh, that's not a question. Per the records management record. That was not right. You both disconnected the telephone? This is motion to withdraw. I have an attorney. You deserve nothing. You mean nothing. My accent is getting so out of control. I gotta calm down. And for her to... Oh my God, this is like the hardest thing I've ever read. You're killing me, Sarah. You gotta get convicted already so I can quit doing this shit.